Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph L. Jordan, founder of the Jordan UCMJ Law Group. Joseph is a former Army prosecutor who now defends service members worldwide against criminal and administrative charges under the Uniform Code of Military Justice. Based near Fort Hood in Texas, he's known for his blue-collar, smash-mouth approach to litigation and a record that includes hundreds of court-martial cases tried to verdict. I'm Leanne Lyon, and today we're getting to know the man behind the mic, his background, his mindset, and why he calls himself the Courtroom Quarterback. This is Episode 1, The Courtroom Quarterback, Who I Am and How I Try Cases. Joseph, welcome.
Thank you.
For those meeting you for the first time, how do you describe the work you do and who you serve today?
Well, I serve those who serve this nation. It's important that they get the best possible representation under the circumstances that they're facing. And I hope I bring a little sanity to the process. You'd be surprised at some of the crazy things that we see on charge sheets or in various case situations. And so our goal in what we do and what we do at my firm, and I say we because it's not just me, it's my senior paralegal, my executive assistant. We have a couple other counsel that work with us, Justin Scheider, and we just brought in Nick Dauschmidt in Italy. We want to bring the best resolution possible for each and every one of our clients. And so the work that we do is extraordinarily important to that end and that goal.
Well, wonderful. I am excited to dig into a little bit more of your background as well. You started as an Army prosecutor and eventually built a worldwide defense practice. What drove that transition, and what did you take from your time on the government side?
Sure. So necessity drove the transition. I left the Army in 2011, and so I've been in private practice now since then. And when you get out, you have to figure out, well, what are you going to do? And you naturally gravitate to the things that you're interested in, the things that you want to do, the things that you're good at. And I happen to be good at litigation, and I wanted to stick with that. And I wanted to defend service members and stay in the courtroom as much as possible. And so a few gracious individuals helped me set up my shingle and my virtual shingle, as it were, and away we went. So, I've been in the Army since I was 17 years old at that point. And so the Army was really and truly all I had known as an adult, as you could say. And so I wanted to stick and stay with something that was natural to me and would allow me to continue to be around the uniform, to be around the service. And I'd say that in my time as an Army prosecutor and now almost 15 years as a defense counsel, the takeaway from that time is you want to ensure that you critically analyze every case file that comes in front of you. I think it's critical analysis and critical thinking about your case. And a lot of people, you say critical thinking, you don't necessarily know what that means until you actually execute it and practice it. So.
Well, and it sounds like you have seen a few cases. You've tried more than 240 court-martials to verdict and litigated over 350 cases across the United States, Europe, the Middle East, and Asia. When you look back at the scope of work, what stands out most for you?
I would say the relationships that I've developed through what I term as this crazy business. And this business has seen a lot of changes over the years. But there's several counsel that I've worked with over the years that I remain friends with. There's a couple that come to mind right now where, one who's currently stationed out in Asia, we tried and won 7 cases together. And we talk almost on a weekly basis. And he's still in the Air Force. There's Army counsel that I have on speed dial. Some that I currently work with, some that, it's been years since we worked with, but, if I happen to be in that region of the country, we talk. So the relationships is really important, I think, and then developing the relationships with the various experts that I've worked with in the various forensic sciences, whether it be DNA analysis, digital forensic analysis, psychiatrists, psychologists, being able to pick up the phone and talk with them on a regular basis, and you develop a relationship, and you develop in many cases a friendship. They get to know you. They get to know a little bit about your family because if they're I remember when we lived at Fort Hood, in Killeen, we had experts come in. My wife and I would take them out to dinner and what have you. So those relationships are really, really important. And then I'd say the second thing is remembering to stay humble. I would say that humility is something that's rather difficult for me. I have a natural bent towards arrogance. And it's something that I've really had to work on. And life will humble you, and but sometimes you get into that, you just get into it, and it's easy to forget where you came from and forget where you can fall to. So humility and relationships are how I would answer that question.
Yeah, I couldn't agree more. I think relationships are really everything, but wow, to admit that humility is a challenge, wow, I'm just a little that's beautiful. That's hard for somebody who struggles with it to actually say out loud, and you just did.
Yes, ma'am.
Can you take us inside of one of those cases, that really shaped how you practice today? Maybe under one of the 9 victim sexual assault acquittals? Those are tough cases.
Yeah, I've had two of those actually. Tried two 9 victim sex assault cases, and I would say this: it really forces you to focus on several things. One, your leadership skills. Two, how your refined approach to winning a particular case. And it really forces you to break down every charge of every alleged victim. I want to roll back. So with the leadership piece, with a 9 victim sex assault case, in both cases, I had a robust team of experts. So you could have a DNA expert, you could have several psychologists, you could have a psychiatrist, you could have a digital forensic expert. In one of those cases, I had to have a neuro physician, basically, so a neurologist who's also a physician, and I had two of those. And so you have to learn how to manage all those personalities and make sure that they're properly engaged in the work that needs to be done. And then, of course, getting back to the charges themselves, when you're looking at each alleged victim, you have to break them down to their essential components. It's like taking a Lego set that's complete and then breaking it all the way down to each and individual piece of Lego, and then reassembling it to understand how it came to be in the first place. Why are you making this allegation? What are your motivations? What are the faults in what you're saying? And so it really forces you to hyper focus on each and every one, because you don't want to miss anything. You cannot, you can't gloss over anything. So your preparation is extraordinarily vital in a case as big as that.
Wow, that's heavy stuff. It's important things, though, and obviously you've thought through this a lot. And I know you once tried a child sexual assault case where your client actually went AWOL just before trial. You literally had an empty chair next to you. What was that experience like, and how did you keep the panel focused on the evidence instead of the optics?
That was a wild case. It was a crazy
Okay.
case because I found out 2 weeks prior to trial that he had bounced. He had absconded to the Philippines with his family, and
Wow.
I usually fly in about a week in advance of trial, unless it's one of those big cases we just talked about, and then 2, 3, 4 weeks in advance. So I fly into Alaska about a week in advance, and my co-counsel's freaking out, and we can't try this case. We can't try this case. Yeah, well, he's been arraigned. He's voluntarily absented himself, so we're trying the case. So we got to get it together, and you have to figure out what the focus is going to be, right? What was the focus of the case? Because originally I was going to have my client testify, his wife was going to testify, um, I had to recenter the case and refocus on the alleged victim, and really you pick out a big issue and then you shape everything around it. And I had basically 2 weeks to do that. I had a really good expert that gave me some great advice. He consulted me on the case actually for free. I didn't have to get the government to pay for him, nor did I have to pay for him. I had flown into Seattle on another case, and I had some extra time, so I went up to Gig Harbor and met with my good friend, who's also a forensic expert in psychology, and he gave me some good advice, and I ran with it. And what was interesting is it wasn't just changing how you prepped for the case and how you executed it. Once we got in there, we had another challenge, which was we had a psychologist on the panel. And the rule of thumb is you get rid of those, right? You don't want what's known as a lie detector on the case. So as we went through the voir dire process, which is the process in which you select members to sit in the panel, I liked his answers. My co-counsel was freaking out again. It's like, we can't keep him, we can't keep him. I was like, yeah, but I like what he has to say. The alleged victim was Asian. The family was Asian. The psychologist was Asian. He ended up being the president of our panel, and we got a full acquittal in that case. And what was important was the panel didn't know why my client wasn't there. All they were told was that he voluntarily absented himself, which is what the rules require. They cannot tell how they voluntarily absented themselves. So the panel didn't know he was AWOL, which is really, really a key component. And they're not always AWOL. Sometimes they just can't handle the process. But it's really, really rare that someone would not show up to their own court. But that was that's one of the pinnacle moments of my career, actually, to be able to win a child sex assault case without your client sitting there. That was a tough one.
But you've talked it before, you've mentioned to me that false confession cases come up quite often in your practice. What patterns do you see, and how do investigators get it wrong? How do you break those down in court?
I say that the number one thing that I see with interrogators is that they already have a conclusion already. So when they go in to question an accused, they already know the answers to the test, and they don't waver. Now, investigators are supposed to be objective, but I have found that investigators don't even know what that means. I was cross-examining an investigator at Fort Drum, New York, a couple of months ago, and he quite literally said on the stand, "I'm sorry, counsel, I don't know what that means." And of course, I had my way with him at that point, because investigators are trained to be objective. But that was a case in point, and what I see in these false confession cases is that they have a conclusion in mind. The accused is telling them what their story is. This is what happened. No, no, no. Let's get past that. I want to talk about this because this is what happened. Now, where did they get that story? Well, they got it from the alleged victim, right? So they're really trying to force these guys and stovepipe them into what their narrative is. Because let's just face it, if an investigator gets a confession, quote unquote, the case is easy at that point. They can close their file. There's not much else they need to do because they got the confession. So I think it's one, having that tunnel vision and understanding that they already know the answer that they want, and they really try to focus the accused on that. And I can't tell you how many times I've seen the case where an accused just finally just gives up. They're just like, you know what? I'm going to tell you what you want to hear. And it astounds me that prosecutors think it's okay to take a case like that into the courtroom. And I can remember a Marine case that I did a couple of years ago, and the family called me saying, "Hey, the Marine Defense Council really want our son to take a deal. It just doesn't smell right." So I took a look at the case, and I realized I can see why you think he confessed, but this isn't a confession. And I mean, it might have been a 50-50 case, but it was a matter of really unpacking what the kid said, particularly at the end of his statement, and then re-engaging because the prosecutors put the video in evidence. So I was able to pull out all the great statements that he said. And then, of course, on cross-examination of the agent, I pointed out the fact to the members through cross-examination of the agent that you can lie to them, can't you? And you can try to lie to them to manipulate them to get them to say what you want them to say. And so investigators in NCIS, Army CID, Air Force OSI, Coast Guard, CGIS, they're all authorized to lie to an accused. That's permissible. And a lot of members can't stomach that because integrity is everything in the military. If you don't have integrity, if I can't trust the man next to me or the woman next to me, who can I trust? So,
Wow, very, very good points. And we are coming close to the end of our first episode, but a couple more questions for you. You describe yourself as a blue-collar trial lawyer. What does that mean in your day-to-day work, and how do you relate to clients in uniform?
sure. So I grew up in a farming community in Kansas. Basically, I grew up on the farm. You get up 5:30 in the morning, do your chores, take care of the animals, and then go to school. You come home, you work till the sun goes down, and then you get to do your homework. And so that mentality has never left me. That's the mentality I had when I was in the Army. That's the mentality that I've had since I started my business. And you just have to be willing to work. That's the bottom line. Put the work in. Don't be lazy, because the stakes are extraordinarily high. And let's be honest, we charge high fees, and so you put the work in, and that's just what it is. It's being willing to put the work in and being willing to brave adversity wherever it comes. You may have adversity in getting what you need out of your client, or getting what you need out of a witness on the stand, or dealing with a curmudgeon-y judge, or what have you. You just push through it. You just got to keep marching forward, one step at a time. Don't give up.
Finally, as we wrap up here, what should listeners expect from this podcast as it unfolds? And why do some people call you the courtroom quarterback?
Well, I think my body of work at this point is kind of allowing me to talk more and more about my experiences. And I think that the types of cases that I've tried, the volume of cases that I've tried, is now allowing me to kind of share and speak with some authority about what it takes to win these cases, what a potential service member should possibly be looking for in counsel and representation. And so I think I think why people refer to me as a courtroom quarterback is the one, they know that my love of the game, and two, they see the correlation between what it takes to win a football game, the preparation, the practice, and then the execution. Because not everything is scripted, right? You have your plan, you have your playbook, but then you get on the gridiron, or you walk into the courtroom, and things change, and you have to be ready for those changes. And as the quarterback, sometimes you're called on to call the play, right? You have to call an audible. Then you got to execute, and sometimes that play breaks down, and the only person that can solve that problem, solve that play, deal with that issue is you. And so you have to, and you got to execute. There's not a lot of room for failure. And so I think what people can look forward to is a lot of stories and application to those stories to what are the particular subjects that we may be talking about.
Beautiful. Well, that's it for today's episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney. If you'd like to learn more about Attorney Joseph L. Jordan and his work with the Jordan UCMJ Law Group, visit jordanucmjlaw.com. Then you'll find case resources and information for service members facing UCMJ charges worldwide. Thanks for listening, and don't forget to like, subscribe, and leave a review if you enjoyed today's episode. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.